Arraignment under Rule 116, it's the formal mode and manner implementing the constitutional right of the accused to be informed of the nature and cause of the accusation filed against him. So it is already a mode of telling him the cause and nature of accusation filed against the accused, and it is very indispensable, necessary, and important. What if there is no arraignment? In the absence of arraignment, it will result the proceeding as null and void. It's null and void if the absence of arraignment. How about if the judge found out that the accused was not yet arraigned, but the proceedings has already been submitted for decision? The accused, despite not having arraigned, did not object to the continuation of the proceedings and actively participated in the trial. So here in this case, the trial judge later discovered that there was no arraignment was made for the accused, and the defense counsel of the accused did not even object in the absence of arraignment. So the issue here, will the trial proceeding be still valid? The answer is yes. The trial is valid even in the absence of arraignment. Why? The accused deemed to have waived the defect of arraignment. Further, he is deemed to have been informed of the nature and cause of the accusation against him because he actively participated in the trial. So, in this case, since the accused actively participated in the trial proceeding, even in the absence of arraignment, it is already presumed that the accused knows already the nature and cause of accusation filed against him. So therefore, the entire trial proceeding is valid. How arraignment is made? Simply, it is being made in open court by the judge or clerk by giving the accused with a copy of complaint or information, and reading such complaint or information in the same language or dialect known to him, and asking him whether he pleads guilty or not. What should the court do if the accused refuses to plead? The accused does not want to plead. So this time, a plea of not guilty shall be entered for him. That is under paragraph C, section 1, rule 116. When the accused pleads guilty but presents exculpatory evidence, so his plea shall be deemed withdrawn and a plea of not guilty shall be entered for him. So again, the refusal of the accused to make a plea of not guilty shall be entered, and if he pleads guilty but presents exculpatory evidence, then the plea shall be deemed withdrawn and a plea of not guilty shall be entered in the record. Is the presence of the accused required? Yes, it is mandatory that the accused should be arraigned personally, and he must enter his plea personally. Both arraignment and plea must be put in record, but failure to put in record shall not affect the proceeding. So again, the presence of the accused is mandatory. He needs to enter his plea personally. How about the presence of the offended party? Not actually required. The arraignment can proceed without the offended party. But if they want to bargain, the offended party shall be required to appear at the arraignment for purposes of plea bargaining, determination of civil liability, and other matters requiring his presence. Failure to appear despite notification, accused may be allowed to enter his plea of guilty to a lesser offense, which is necessarily included in the offense charge with the conformity of the trial prosecutor. That is in paragraph F, section 1, rule 116. So here, as a general rule, the presence of the offended party is not required, But if the offended party wants to bargain, then they shall appear at the arraignment, and also to determine the civil liability and other matters. But failure to appear, or the offended party did not appear during arraignment despite notices given to them to attend arraignment, now the accused may be allowed to enter his plea of guilty to a lesser offense, and such lesser offense is necessarily included in the offense charge with the conformity of the trial prosecutor alone. So here, in the absence of the offended party, the accused may plea of guilty to a lesser offense with the consent of the prosecutor alone. The duty of the court before arraignment is to inform the accused's rights to counsel and ask him if he desires to have one. Unless the accused is allowed to defend himself in person or has employed counsel of his choice, the court must assign a counsel officio to defend him under Section 6, Rule 116. If the accused cannot afford to have a counsel, a court must provide him one. A counsel de officio can be anyone who is a good member of the bar, appointed at the discretion of the judge. Whenever a counsel de officio is appointed by the court to defend the accused at the arraignment, he shall be given a reasonable time to consult with the accused as to his plea before proceeding with the arraignment. So in this case, the duty of the court is to ask the accused to have a counsel. He may also defend himself, but he is given the choice to have one. If the accused cannot afford to have a counsel of his choice, preferably of his own choice, then the court will assign him one. Then that is already counsel de officio. So these are the remedies of the accused before arraignment. The defense counsel may file for bill of particulars, specifying informations alleged in the complaint or information to make it more simplified. Motion for suspension. Motion for suspension on the ground of prejudicial question. It can be. And motion to quash on the ground that the court has no jurisdiction over the person of the defendant, no jurisdiction over the offense charge, the facts alleged in the complaint does not constitute offense charge, and there is no authority for the prosecutor to file an information, and there is non-compliance of information in the prescribed form as stated in Section 6, Rule 110, and there is already double jeopardy. And also, motion to quash on the ground of violation of duplicity principle, where there is two or more offenses alleged in the information. And the last, extinction of criminal liabilities. Another is to question validity of warrant or arrest. And the next remedy is the modes of discovery. When does arraignment starts? So, when the accused is under preventive detention, his case shall be raffled and its record transmitted to the judge to whom the case was filed or raffled within 3 days from filing of the information or complaint. The accused shall be arraigned within 10 days from the date of raffle. The pretrial conference shall be conducted on the day of arraignment. So again, if the accused is already detained under preventive detention, detained already, so the case shall be raffled and the records shall be transmitted to the court where the case has been raffled. It should be made within 3 days from filing of information or complaint. So within 3 days lang. And then after that, the accused shall be arraigned within 10 days from the date of raffle. Then the pretrial conference shall be conducted on the day of arraignment. What if not a detainee, not yet arrested, or not yet a detained, not yet under detention? So the arraignment shall be held within 30 days from the date the court acquires jurisdiction over the person of the accused. Again, the arraignment shall start within 30 days, within 30 calendar days from the acquisition of the court its jurisdiction over the person of the accused. The time of the pendency of a motion to quash or a bill of particulars or other causes justifying suspension of the arraignment shall be excluded in computing the period. Again, the time of pendency of a motion to quash or bill of particulars or other justifying motion for the suspension of arraignment shall be excluded from the computing period. That is under paragraph G, section 1 of Rule 116. During arraignment, again, the court shall enter plea of the accused if the accused refuses to enter plea. So it is already presumed to enter not guilty. Plea of not guilty. And also if the accused makes a conditional plea. And also, if the accused pleads guilty but presents exculpatory or acquittal evidence, so the court will enter plea of guilt. The court will enter a plea for the accused. So plea bargaining agreement. This is principally a contract. Plea bargaining agreement is a contract between the accused and the prosecutor, whereby the judge is not a party. There must be a consent by the offended party and the prosecutor to make the plea valid. Without consent of the prosecutor, the plea bargaining agreement is void. The plea bargaining. The plea bargaining is a process whereby the accused and the prosecution work out a mutually satisfactory disposition of the case, subject to court approval. It usually involves the defendants pleading guilty to a lesser offense or to only one or some of the counts of a multi-count indictment in return for a lighter sentence than that for the graver charge that is in Daan versus Sandigan Bayan. So here in plea bargaining, the defense, the accused here is pleading guilty to a lesser offense or to only one or some of the counts of a multi-count indictment in return for a lighter sentence than that of a graver charge. So bargaining, begging for a lighter offense than a graver charge. So there is already bargaining here. The bargaining needs the approval of the offended party and the prosecution. When to make a plea to a lesser offense? You can make it during arraignment proper. It can also be made after arraignment but before trial and after the prosecution rested its case. So, in entering plea to a lesser offense during the arraignment proper, these are the requisites. The lesser offense is necessarily included in the offense charge. Otherwise, plea to a lesser offense cannot be made. So, the lesser offense should be included in the offense charge. And the plea must be with the consent of both the offended party and the prosecution. So it's very important that the offended party must be present during pre-trial, because failure to appear despite notification, failure to appear by the offended party despite notification, the accused may be allowed to enter plea of guilty to a lesser offense with the conformity of the prosecutor alone. Those are the requisites for entering plea to a lesser offense. How about after arraignment but before trial? The accused may still be allowed to plead guilty to a lesser offense after withdrawing his plea of not guilty, and there is no need for amendment of the complaint or information. Again, after trial but before after arraignment but before trial, still the accused can enter to a plea of to a lesser offense by withdrawing the plea of not guilty. How about after the prosecution rested its case? It was held yes, the accused can still plea to a lesser offense during the trial proper, or even the prosecution has finished presenting its evidence and rested its case. So even though that there is already rested of case on the side of the prosecution, the accused may still enter its plea to a lesser offense, provided that lesser offense is necessarily included in the offense charge and with the consent of both offended party and the prosecutor. This time, let's go to plea bargaining in drugs cases. As a general rule, under Section 23 RA 9165, any person charged under any provision of this act, regardless of any imposable penalty, shall not be allowed to avail of the provision on plea bargaining. So that is those who violated RA 9165 cannot avail plea bargaining. However, in Estafa versus Lobrigo case, Supreme Court held that Section 23 RA 9165 is unconstitutional. The reason why is that the purpose of investigative directive is to set policy and guidelines that shall be observed by PNP personnel in the plea bargaining of criminal cases involving victimless crimes. So this is one of those victimless crimes. So this is to be followed. Plea bargaining framework in drugs cases, Administrative Memo number 180316 SC, in which the pusher under Section 5 can plea to Section 12, that is possession of equipment of apparatus. Section 5 is person caught of selling or pushing drugs. Pusher. Yes, he can plea from Section 5 to Section 12, provided that shabu should be less than 1 gram. So again, if the shabu is less than 1 gram, the accused can plea from Section 5 from being a pusher into a possession of equipment or apparatus. It can also plea from Section 5 to Section 11, wherein from selling, plea into an offense of possession of dangerous drugs, provided again that less than 1 gram. For marijuana, it's less than 300 grams. If more than that, plea bargaining shall not be allowed. Next, Section 11. For accused violated Section 11, wherein possession of dangerous drugs, can plea into Section 12. Section 12 again, that is possession of equipment or apparatus, provided that shabu shall be less than 5 grams. Again, section for violation of Section 11, the possession of dangerous drugs, can plea into Section 12, provided that shabu is less than 5 grams and marijuana is less than 300 grams. Person is a visitor in a drug den. He violated Section 7. But he can plea into Section 15, provided that shabu is less than 5 grams and marijuana is less than 300 grams. More than 5 grams and more than 5 grams for shabu and more than 300 grams for marijuana, the accused cannot apply for plea bargaining. In Pasqua versus People, the accused was charged of Section 5, that is selling or pushing dangerous drugs, and plead to a lesser offense that has a probationable penalty. He applied for probation but was denied by the trial judge. The Supreme Court said that the trial court is incorrect in not granting the probation. In People versus Riafol, a plea bargaining judgment which is rendered by the court over the objection by the prosecutor is void. Why void? The court cannot render judgment on plea bargaining over the objection of the prosecutor. The court cannot make judgment on plea bargaining if the prosecution disagrees with it. It is because it violates Section 2, Rule 116. There is no consent by the prosecutor. There is objection by the prosecutor on the plea bargaining. Then the court make a judgment on that. So that is void. This time, let's go to pleaded guilty to a capital offense. Under Section 3, Rule 116, the court shall conduct searching inquiry into the voluntariness and comprehension of the plea, require the prosecution to prove his guilt and precise degree of his culpability, allow the accused to present evidence in his behalf. So here, the accused plead guilty to capital offense. What are those capital offense? Death, reclusion perpetua, or life imprisonment. So therefore, the court is searching for the voluntariness and comprehension of the plea made by the accused. Is it clear to the accused that the consequence of pleading guilty to a capital offense? Is it voluntary, or he understands the nature of the and cause of these capital offenses? So that's the job of the court to determine it and require the prosecution to prove guilt and culpability. Guidelines concerning plea of guilty to capital offense. This is from the case of People versus Pagal. At the trial stage, when the accused makes plea of guilty to a capital offense, the trial court must strictly abide the provision under Section 3, Rule 116 of the Rules of Court. In particular, it must afford the prosecution an opportunity to present evidence as to the guilt of the accused and the precise degree of his culpability. So again, it is the job of the court to search the voluntariness and comprehension of the plea made by the accused to a capital offense. Otherwise, failure to comply the Section 3 Rule 116, there will be grave abuse of discretion. In case the plea of guilty to a capital offense is supported by proof beyond reasonable doubt, the trial court shall enter a judgment of conviction. In case the prosecution presents evidence but fails to prove the accused's guilt beyond reasonable doubt, the trial court shall enter a judgment of acquittal in favor of the accused. In case the prosecution fails to present any evidence despite opportunity to do so, the trial court shall enter judgment of acquittal in favor of the accused. So again, it is the job of the prosecution to establish the guilt of the accused beyond reasonable doubt. Otherwise, presentation of evidence but those evidence presented is not strong to reveal the guilt of the accused, then therefore the court shall make a judgment in favor of the accused, which is acquittal. The trial court shall require the prosecution to explain in writing within 10 calendar days from receipt of its failure to present evidence. In case the prosecution failed to present any evidence, any pieces of evidence to prove the guilt of the accused, any instance of collusion between the prosecution and the accused shall be held with to full extent of the law. So It's the job of the court to check if there is collusion between the prosecution and the accused. For sure, there will be money making. That is why prosecution did not present any evidence. That will lead the trial court to dismiss the case, to acquit the accused. At the appeal, when the accused is convicted of a capital offense on the basis of his plea of guilty, whether improvident or not, and proof beyond reasonable doubt was established, the judgment of conviction shall be sustained. Again, on appeal, if there is strong evidence, the guilty is beyond reasonable doubt was established, therefore the judgment of conviction shall be sustained by the appellate court. When the accused is convicted of a capital offense solely on the basis of his plea of guilty, whether improvident or not, without proof, beyond reasonable doubt, because the prosecution was not given an opportunity to present its evidence, or was given the opportunity to present evidence but the improvident plea of guilt resulted to an undue prejudice to either the prosecution or the accused, the judgment of conviction shall be set aside and the case remanded for rearraignment and for reception of evidence pursuant to Section 3, Rule 116. So in this case, wherein the accused is convicted to a capital offense based only on his plea of guilty but without any proof presented by the prosecution, or prosecution was not given the opportunity to present its evidence. So therefore, the judgment of conviction by the trial court shall be set aside and the case shall be remanded for rearrangement and for reception of evidence in trial. So it is very important that prosecution builds the guilt to convict the accused, otherwise acquit the accused for not proving the guilt. What if the accused pleaded guilty to a non-capital offense? This is under Section 4, Rule 116. When the accused pleads guilty to a non-capital offense, the court may receive evidence from the parties to determine penalty to be imposed. Take note that the presentation of evidence is mandatory, while the reception of evidence is only discretionary. The purpose of this is to determine the penalty to be imposed. So therefore, reception of evidence is discretionary. Hearing to determine the penalty to be imposed is not mandatory because reception again of evidence is discretionary with the courts. A plea of guilty can be withdrawn anytime before judgment becomes final. The court may permit the accused to withdraw the plea of guilty and substitute it with plea of not guilty.